The courtroom went silent. A killer just walked free, and it was completely legal. The loophole? Written in 1843, and prosecutors still can't close it. January 1843. London. A man named Daniel Nitton walked up to the British Prime Minister's secretary, and shot him dead in broad daylight. But here's where it gets strange. Nitton believed the government was persecuting him. Voices in his head told him the Prime Minister was his enemy. When the case went to trial, doctors testified that Nitton couldn't distinguish right from wrong. The jury acquitted him. Not guilty by reason of insanity. The public was outraged. Queen Victoria herself demanded answers. How could a confessed killer walk free? But that verdict created something that still haunts courtrooms today. The Nitton rule became the foundation of every insanity defense in the English-speaking world. And this is where the controversy begins. Because what happened next would divide legal scholars for the next 200 years. Now, here's where most people get confused. Legal insanity is not the same as mental illness. You can be diagnosed with schizophrenia, bipolar disorder, or severe depression, and still be found legally sane. Think about that for a second. The law doesn't care if you're mentally ill. It only cares if you understood what you were doing at the exact moment of the crime. The Nitton test asks two questions. Did the defendant know the nature of their act? And did they know it was wrong? If someone stabs a person believing they're cutting bread, they don't understand the nature of the act. If someone kills believing God commanded them to do it, they might not know it was wrong. But here's the thing. Proving this in court is nearly impossible. Prosecutors have teams of psychiatrists ready to testify that defendants knew exactly what they were doing. And juries? They're skeptical from the moment they hear the words insanity defense. March 30, 1981. Washington, D.C. John Hinckley Jr. fired 6 shots at President Ronald Reagan. One bullet ricocheted and struck Reagan in the chest. 3 other people were wounded, including Press Secretary James Brady, who was left permanently disabled. But the prosecution had one more witness who would change everything. They had psychiatrists ready to prove Hinckley knew exactly what he was doing. The defense countered with their own experts claiming Hinckley suffered from erotomania, an obsessive delusion about actress Jodie Foster. He believed shooting the president would impress her. Let me put this in perspective. The jury had to decide if a man who meticulously planned an assassination, stalked the president for months, and wrote love letters explaining his intentions was legally insane. After 3 days of deliberation, the verdict came. Not guilty by reason of insanity. America erupted. Newspapers ran headlines calling it the trial of the century. And within months, Congress began rewriting insanity laws across the nation. What the jury heard next sealed the verdict on insanity law reform. Within 3 years of the Hinckley verdict, Congress passed the Insanity Defense Reform Act of 1984. The burden of proof shifted dramatically. Before Hinckley, prosecutors had to prove defendants were sane. After the reform, defendants had to prove they were insane. And they had to prove it by clear and convincing evidence. But here's where it gets truly disturbing. States began creating a new verdict option called guilty, but mentally ill. It sounds like a compromise, but think about this. Guilty, but mentally ill means you go to prison anyway. You might receive psychiatric treatment, but you serve your full sentence. Some states went even further. Idaho, Kansas, Montana, and Utah abolished the insanity defense entirely. 4 states where you cannot claim legal insanity no matter how severe your mental illness. The message from legislators was clear. The American public had lost faith in psychiatric testimony, and courts would no longer be a refuge for those claiming they didn't know right from wrong. But, everything I just told you? That's just the setup. Here's what nobody talks about. The insanity defense didn't die after Hinckley. It evolved. Defense attorneys developed new strategies. They stopped claiming their clients were completely disconnected from reality. Instead, they focused on something called diminished capacity. The courtroom went silent when experts began explaining that some defendants understood their actions, but couldn't control their impulses. This wasn't full insanity, but it could reduce murder charges to manslaughter. And then came the neuroscience revolution. Brain scans entered the courtroom. Defense attorneys showed juries images of damaged prefrontal cortexes, the part of the brain that controls impulse and judgment. What would you have done if you saw a defendant's brain scan showing massive abnormalities? Juries started asking themselves that question. The success rate of mental health defenses began climbing again. Not because laws changed, but because science gave defenders new ammunition. And this is where justice was served in the most controversial way possible. Let me tell you about Andrea Yates. In 2001, she drowned her 5 children in a bathtub in Houston, Texas. She called police immediately afterward and confessed. Prosecutors charged her with capital murder. But here's the twist. Andrea Yates had a documented history of severe postpartum psychosis. She had been hospitalized multiple times. Her psychiatrist had warned that she should never be left alone with her children. She believed Satan was inside her, and that drowning her children would save them from eternal damnation. The first trial found her guilty. She was sentenced to life in prison. But then prosecutors made a fatal error. One of their expert witnesses had given false testimony about a law and order episode that never existed. The conviction was overturned. At her second trial in 2006, the jury found her not guilty by reason of insanity. She was committed to a state psychiatric facility. But wait, there's more to this case than the headlines ever told. Here's the truth prosecutors never want you to understand. People found not guilty by reason of insanity don't walk free. They're committed to psychiatric institutions, often for longer than they would have served in prison. John Hinckley spent 35 years in a psychiatric hospital before being released in 2016. That's longer than many murder sentences. Andrea Yates will likely spend the rest of her life in a state facility. The system isn't designed to let dangerous people go free. It's designed to determine who is morally responsible for their actions. Think about this. We don't punish people for accidents. If you have a seizure while driving and kill someone, you're not guilty of murder because you had no control. The insanity defense applies the same logic to the mind. But here's what the data actually shows. Only about 1% of felony cases even attempt an insanity defense. Of those, only about 25% succeed. And of those successful cases, the vast majority involve defendants with documented, severe mental illness who pose significant dangers. The system works exactly as designed. It just doesn't match what movies and television have taught us to believe. So what does this mean for the future of criminal justice? The insanity defense isn't a loophole. It's a recognition that some people genuinely cannot understand their actions. Every civilized legal system in history has acknowledged this principle. We don't execute children because they lack full moral understanding. We don't imprison people in comas. The question isn't whether mental illness should matter in court. It's where we draw the line. And that line keeps moving as neuroscience reveals more about how the brain actually works. Some legal scholars predict that within 50 years, brain scans will be as common in courtrooms as DNA evidence is today. Others warn this could create new problems, making everyone's criminal behavior seem like a product of brain chemistry rather than choice. The debate that started with Daniel Nitton in 1843 isn't over. It's just entering a new phase. And every jury that hears an insanity defense is deciding not just one person's fate, but what we believe it means to be truly responsible for our actions. Now you understand why the insanity defense remains the most controversial legal strategy in American courtrooms. It's not about letting criminals escape justice. It's about asking the hardest question in law. When is someone truly responsible for what they've done? Subscribe for daily courtroom breakdowns where justice is served. We cover the trials that shock the nation. What case should I analyze next? The verdict is in your hands. Drop it in the comments.